also using empirical and field research. So it's my great pleasure to welcome Fabrizio Cafaggi.
So sorry for this positioning, but to save time, it's better that I speak from here. I want to start with an expression of gratitude and apologies. Gratitude for being invited here, also because I think it's a very interesting project. But those of you who know me can imagine that despite the fact that I think it's a great initiative, I think we're having problems talking to each other. I think it's clear that here there are two streams of scholarship, maybe more. Everybody's trying to talk to the other, but I still think that the divide is pretty big. And so my apologies to Crystal and Jan are related to the content of the talk. But I hope at the end I'll make a good service to the conference. So instead of talking about contract law and regulation, what I'm going to try to do is basically, instead of making some statements, ask some questions about how these two streams can be bridged. And so hopefully this will trigger some discussion and enable us to try to have a common language on these two issues. So I think the reason why I was asked first to come is for a couple of books that Horatia Watt and myself edited about 4 or 5 years ago. And those books were primarily addressed to my fellow colleagues in private law. And one of the main issues that we're trying to raise is that up to that point, we're talking 2005, that's when the project started, European private lawyers had been focusing primarily on harmonization of rules, giving very little of no attention to the institutional setup. And so the issue was primarily what kind of rules we need, but when it came to what kind of instrument we need to make sure that those policy objectives were achieved, very little was said by private lawyers. Things have changed. I think one of the many positive externalities, there are also many negative externalities of the optional instrument, is that private lawyers in the last 2 or 3 years have started debating about instruments. And so they realized how important it is that instead of focusing simply on rules, we need to be talking about institutional design and choices. So I think the first point is that European private law should engage into a debate about institutional design, choice of instruments. The second point we were trying to make in that book was about implementation. European private lawyers, despite the fact that they are primarily coming from national law, ended up concentrating primarily on European law and little about ways in which implementation took place, especially implementation by the courts, but the different techniques of implementation. And I'll say a few things in practical terms, because I'd like that to be part of a RIA specifically devoted to European private law scheme. So the issue is to what extent European private law is not only about institutional design at the European level, but implementation and what is the connection between the two. And the third one, which is connected, is we need to be looking at the relationship between the choice of instruments and the type of rules, so that, for example, it is not irrelevant if we choose soft law or hard law, if within hard law, for example, we choose mandatory rules or default rules, and what kind of default rules we choose. So the choice of instrument should not be the only kind of concern, but the content, the choices among rules, is of paramount importance. So if we take seriously institutional design as part of the project of Europeanization of private law, we need to be thinking about a methodology to choose among different instruments. And so I want to locate this debate into the question of the extent to which the regulatory impact assessment should have a specific role in the process of Europeanization of private law, which gives us two questions. The first one is there anything specific about regulatory impact assessment concerning European private law? Or we can apply regulatory impact assessment across the board. If the answer is that there isn't anything specific, we can thank Crystal today for making possible that we met. But basically, we go home and say to Andrea, Alberto, and all the others, just continue to do your job, and we'll continue to do ours. But the main problem is not yours, it's ours. If the answer is yes, then some of the questions that were addressed need to be tailored to make sure that the regulatory impact assessment will take care of some of the questions that European private law poses. Let me try to explain why Crystal's initiative is not useless, and I want to focus on three dimensions. First, implementation. So when we engage into a process of adoption of a soft law or a hard law instrument, we need to be asking ourselves what kind of implementation strategies is in place. So let me give you one example that we're all familiar with, consumer protection. We basically have had three strategies. One is the German strategy, integration into the civil code. The other one is the Italian, Spanish, French, and other strategies, creation of a separate consumer code separate from the civil code. Another one is the English strategy with the statutory implementation associated with judge-made law. Now, for the purpose of the objectives of a directive, is it relevant or irrelevant that one of the three strategies is adopted? I fully understand that there's a principle of institutional autonomy there, but I do think that regardless of whether we tackle the issue as an issue of European law or national law, the problem of implementation really depends upon how these different strategies are combined. So I'm not advocating a single strategy for implementation. Even if you leave the scope of the institutional autonomy principle as it stands now, what I would like to see in a regulatory impact assessment is a forecast of how a single directive or regulation might have an impact if I use an integration strategy into the civil code, a separation strategy by creating a separate consumer code, or a primarily judge-made law dimension. I think that is specific of European private law, but it would be something that could help European policymakers and national policymakers to think about the extent to which policy objectives of harmonization are achieved. Second principle, I'd like to see more in a regulatory impact assessment, which I think links up the process of European private law with RIA, effectiveness. Again, we run into a potential obstacle, which is the principle of procedural autonomy. So the previous one is institutional autonomy, this one is procedural autonomy. I don't need to tell you that more and more we see directives, regulations, and soft law, including remedies. We've just heard a presentation about environmental liability where remedies were there. The optional instrument is full of provisions concerning remedies. So I think there is a contraction of the principle of procedural autonomy. But here again, is it possible that we do not see in European private law directives any analysis concerning the impact of the choice between administrative versus judicial versus arbitration versus ADR. And isn't that an element that would affect the principle of effectiveness? So again, I believe that this dimension, and I know in the private enforcement this has been done, but I'm saying how can we generalize a matrix to analyze the enforcement strategies and their combination into each European private law directive that would allow us to understand what is the link between substantive and procedural rules and ensure that at times of implementation at the national level, we would have a good analysis and a good feedback on how these provisions are implemented, whether or not they are effective. And the third dimension, which I think is the hardest in terms of conceptual scope, but I think it's very important, is the relationship between proportionality and private autonomy. I think this links up with what I'm going to say about the optional instrument. So the principle of proportionality, I think, in the analysis in the regulatory input assessment has been seen primarily, and that's where it comes from, as an issue concerning the proportionality of the legal instruments. Little has been said about the link between the nature of the legal instruments and the power which is conferred on private parties to use that legal instrument. Okay? So, but just to give you a concrete example, if I apply the analysis of proportionality to the choice between an instrument which is full of mandatory rules vis-a-vis an instrument which is full of default rules, I end up having a very different view of the proportionality principle. So I need to move from the simple hard law, soft law regulation directive to a content-based analysis to make sure that the proportionality will open the access. And this is a suggestion. These three were for Andrea. This one is for Alberto. So we can, I think, fruitfully apply the behavioral analysis of default rules, mandatory rules, enabling versus disabling to the principle of proportionality. And we could use it in the RIA and clearly increase our understanding by proposing a new test of the proportionality principle if we link it up, the choice of instruments, with the content of the rules. So these are only three examples which I think might be generalized but do have a particular take in the RIA analysis that shows how much benefit European private law would get out of tailored regulatory input analysis. So the answer, in my opinion, to the question, do we need a specific RIA, is not so much on the principle, but it's on its implementation. So depending on the choice that will be made at the European level, we're going to have only guidelines that define the principles, and we let each directorate to choose what are the specific dimensions that are associated to sectors, or are we going to define some type of procedure, at least conceptual procedure, that would allow the Commission to say, when we're engaging into European private law analysis and choice of instruments, that's what you should do in terms of the general principles. So a second step. Now, my last part is an attempt to be a little bit less abstract and see, I think, one concrete example. And then when I was listening to Linda and Anna's, I thought they're going to be talking about the principle of tort law, right? And so my expectation was here a real nice case study would be how do we choose between the principles of tort law and a directive or regulation. So whether the benefits of soft law, somewhat associated to the idea of working with principles like the PECL or the PETL, would be contrasted with the idea of using directives or regulation in tort law and contract law. Now, this debate, to my knowledge, has taken place much more in the contract law side, much less in the tort law side. But the debate in the contract law side with the optional instrument has been a debate on basically whether we want to achieve harmonization through the conventional top-down instruments, regulation and directives, or through the optional instrument where harmonization is by choice and not by command. So I want to focus on these narrow alternative, harmonization by command and harmonization by choice, and link it up with the regulatory nature, the regulatory landscape that has to be associated with the choice of one or the other. The optional instrument is an harmonization by choice instrument. So the question there is, when I define an instrument where the choice of harmonizing European law is given to individual parties that might or may not choose that specific regime, do I need a specific regulatory framework different from the one I would use if I use Directive 2001/83 on consumer rights? So we can easily juxtapose the two, right? So I have a hard law directive strategy for harmonization of consumer rights, 2011-83, and I have the optional instrument. If you look at the ways in which the regulatory framework is being conceived for both instruments, very little difference exists. But if you go deep into the optional instrument, you wonder first, if I choose an instrument that is based on choice, how do I enable parties to choose? What kind of regulatory instruments do I need to provide for those parties to choose the instrument? Clearly, this is not only a problem of asymmetric information. So what is it? Article 9, the click thing, the consumers who are asymmetrically informed get a one-page explanation from the firm about it. That's not the only issue. Assuming, it's a really strong assumption that consumers will read that page, will understand that page, will choose upon that page. Behavioral law in economics tells us that that's absolutely not the issue. The issue is not whether people read or don't read. The issue is what people make out of reading. Once they read, what do they make out of it, right? So what kind of biases they come with when they read that page. Are they really free to choose or not? So debiasing through law implies that I don't simply send a nice, transparent, plain, and intelligible page to the consumers to enable their choice, but I have to design a framework which will be able to debias whatever biases there are for the parties that have to choose in order to be able to achieve the objectives that I want to achieve, which is to maximize the use of that instrument. And if you look at the optional instrument, the whole regulatory framework which has to accompany the use of an optional instrument is missing. It is missing the culture of choice. I think it's a very nice step, don't get me wrong. I think, I'm not as enthusiastic as Jan about optional instrument, but I think it's a great move forward. Yet, if it is not accompanied by a set of regulatory instruments, intermediaries, infomediaries, debiasing instruments that will enable choices, the whole philosophy of harmonization by choice will be undermined. This was not part of the impact assessment. It should have been part of the impact assessment. I do expect that when we face the alternative between soft law, hard law, regulation, directive principles, I do find these kind of considerations as part of my set of variables that I want to analyze in order to choose. But here, not only we're choosing one single instrument, because within European contract law, we have competing systems, right? So 5 years from now, I hope that some of these guys will make an exposed impact analysis on these two instruments, the optional instrument and the Directive 2001/83, and tell us why one has been used in one context to a certain degree, to a certain intensity by certain parties, and the other one has been used by other parties. That's the way I'd like to think about the issue of regulatory impact assessment exposed when it comes to the implementation. So I think, to conclude, that this is the kind of challenges that we need to pose to the fellows who are not sitting in this room, and there are many, who still think in terms of walls between disciplines and do not engage into interdisciplinary work. But I think the main effort, whatever pace the academics will have is relevant for the students. But what the pace that policymakers will have is relevant for citizens. So I think, in this room, the first objective is to persuade policymakers that we need a major change in terms of the regulatory culture applied to European private law.